What is the doctrine of proprietary estoppel? Proprietary estoppel is an equitable doctrine which will prevent a landowner from going back on a promise or assurance made relating to land which would be unconscionable to do so. Now, it arises as a result of, as I said, a promise, a representation, or an assurance made by a landowner, which causes another person relying on such promise or assurance to act to his or her detriment, and it would be unconscionable to allow the landowner to prevent that person from enforcing such right when it comes to land. So you see, in Jamaica, it often arises in family land matters where a family member would encourage another family member to come on the land, promising them that they would get a house spot if they would bury another family member. There is one lady who said that her aunt encouraged her to pay up all her outstanding property taxes and told her she could go and build her house. Having built, the aunt later transferred the land to her son. The son is now saying he does not know anything about that arrangement and she will have to leave. Now, a court of equity will step in and say, not so fast. You cannot evict her. She will have a right to occupy that house and that land because of the promise made to her. All right? So the doctrine of proprietary estoppel is an equitable remedy, so to speak, and it will prevent people from acting unjustly towards other persons when it comes to land rights. And also, sometimes the court will even order that the land be transferred to the person who acted to their detriment, and or to order money compensation. Now, the assurance or the promise need not be expressed. It can be implied from the conduct of the landowner. And so a court of equity will look at the evidence and decide in the circumstance what is best or suited for that particular set of circumstances. But in Jamaica, in family land situation, that is a regular thing that happens all the time, where people acting on the assurance act to their detriment, and as a result, court of equity will step in to prevent unconscionable conduct of landowners. Now, it happens in informal situation where the persons do not have any formal deed, nothing in writing, so to speak, but they acted to their detriment. So the court of equity will come in to do what is just and right in all the circumstances, and it will prevent a landowner, a dishonest or unfair landowner, or a landowner who is acting unconscionable, to hide behind the fact that there were no paperwork, there were no formal deed. Court of equity will still grant you a right to remain on the land. So those persons who find themselves in similar situation, rest assured, the court will not cause you to walk away, leave your house like that. Because once you were encouraged, enticed by conduct or by express overtures made to you, then the court of equity will step in to prevent that landowner from becoming unjustly enriched. Because if you are to walk away, leave your house, that will cause that landowner to become unjustly enriched. And the court of equity says, no, we will not do that. All right? So I hope I've been able to shed some light and to allay some of the doubts that some persons may have who do not have any formal paper to show that they actually got permission. But even if they had not been given permission, they have evidence to show that they built their houses on these lands, and the landowner acquiesced, did passive agreement, did not come forward and say, no, I'm not allowing you to build. They kind of encourage them to build, and after they have built, they now want them to walk away and leave their houses. No, Court of Equity say no, it cannot happen. So I hope persons understand that the courts are there to help them to maintain their claim against unconscionable family members and landowners. All right? God bless you until we meet again. Amen.